In our last videos, already we have discussed in length about the constitutional remedies which are otherwise called extraordinary remedies as provided under Article 32, 136, 226 and 227 of the Constitution. Besides those remedies, we will discuss certain other remedies which are otherwise called ordinary remedies or equitable remedies. So, under those equitable remedies or ordinary remedies, one of the important remedy is injunction, and the second one, that is the damages, and the third one is the declaratory remedies. So, the very meaning of injunction may be takes, taken as an order of a court addressed to a party to proceedings before it and requiring him to refrain from doing or to do a particular act. The injunction is an equitable remedy. It is a judicial process by which one who has invaded or is threatening to invade the rights of another is restrained from continuing such wrongful act. The said right may be legal or equitable. Injunction may be prohibitory or mandatory. Prohibitory injunction forbids the defendant to do a wrongful act which would infringe the right of the plaintiff. A prohibitory injunction may be temporary injunction or perpetual injunction. So, when it is temporary injunction and are such as to continue until a specified time or until the further order of the court, as it was provided under Section 37 of the Specific Relief Act. It is granted as an interim measure to preserve the status quo until the case is heard and decided. Temporary injunction may be granted at any stage of a suit. Temporary injunctions are regulated by the Civil Procedure Code. For the grant of temporary injunction, the following conditions are required to be fulfilled. So, among those conditions, the first one, the court must be satisfied that the plaintiff has a prima facie case, and secondly, the court's interference is necessary to protect the plaintiff from irreparable loss or at least serious injury. And thirdly, the balance of convenience is in favor of the plaintiff who prays for the grant of the injunctions. And finally, there is no adequate remedy to him for his protection. So, these are the conditions required for a temporary injunction. So, in the leading case, in Chandulal versus Delhi Municipal Corporation in 1978, the Delhi High Court has made it clear that for the grant of temporary injunction, the plaintiff must show that he has a legal right which has been infringed. So also in the leading case Narayan versus R. Baidyanath in 1975, the Karnataka High Court has held that for the grant of temporary injunction, it must be shown that the balance of convenience lies in maintaining the status quo, as also it was expressed by De Smith in his judicial review of administrative action. So, temporary injunction is provisional in nature. It does not conclude or determine a right. Besides, a temporary injunction is a mere order. The granting of temporary injunction is a matter of discretion of the court. And regarding perpetual injunction, it is granted at the conclusion of the proceedings and is definitely the rights of the parties, but it need not be expressed to have perpetual effect. It may be awarded for a fixed period or for a fixed period with leave to apply for an extension or for an indefinite period terminable when conditions imposed on the defendant have been complied with, or its operation may be suspended for a period during which the defendant is given the opportunity to comply with the condition imposed on him, the plaintiff being given leave to reply at the end of that time. So, according to Section 38 of the Specific Relief Act, a perpetual injunction may be granted to the plaintiff to prevent the breach of an obligation existing in his favor, whether expressly or by implication. When any such obligation arises from contract, the court shall be guided by the rules and provisions contained in Section 9 to 25 of the Specific Relief Act. When the defendant invades or threatens to invade the right of the plaintiff to or enjoyment of property, the court may grant a perpetual injunction in the following cases, such as where the defendant is trustee of the property for the plaintiff, or where there exists no standard for ascertaining the actual damage caused or likely to be caused by the very invasion, or where the invasion is such that compensation in money would not afford adequate relief to the plaintiff, or where the injunction is necessary to prevent a multiplicity of judicial proceedings as it is provided under Section 38 subsection 3 of the Specific Relief Act. And as regarding mandatory injunction, when to prevent the breach of an obligation, it is necessary to compel the performance of certain acts which the court is capable of enforcing. The court may, in the discretion, grant an injunction to prevent the breach complained of and also to compel performance of the requisite act as it is provided under Section 39 of the specific relief act. So the mandatory injunction may be taken as a command to do a particular act or to restore things to their former condition or to undo that which has been done. It prohibits the defendant from continuing with a wrongful act and also imposes duty on him to do a positive act. For example, construction of the buildings of the defendant obstructs the light for which the plaintiff is legally entitled. The plaintiff may obtain injunction not only for restraining the defendant from the construction of the building but also to pull down so much of the part of the building which obstructs the light of the plaintiff. For the grant of mandatory injunction, there must be legal obligation on the part of the defendant to perform certain acts, and in addition to it, the court must be capable to enforce them. The jurisdiction of the court to grant mandatory injunction is discretionary. However, the discretion is required to be exercised judicially. It should not be exercised arbitrarily. It should be exercised in accordance with the legal principles. So, as it was decided in Vaishya Degree College versus Lakshmi Narayan in 1976 by the Supreme Court, so also in the leading case, Administrator of the City of Lahore and Abdul Majid, the plaintiff submitted a building plan to the municipal authority for grant of necessary permission. Initially, the permission was granted, but thereafter it was revoked. The permission was granted in respect of other buildings. So, mandatory injunction was granted by the court against the municipal authority. So also, damages in lieu of or in addition to injunctions are provided under Section 38 and Section 39 of Specific Relief Act. So, as the plaintiff in a suit for perpetual injunction under Section 38 or mandatory injunction under Section 39 may claim damages either in addition to or in substitution for such injunction, and the court may, if it thinks fit, award such damages. So no relief for damages shall be granted under this section unless the plaintiff has claimed such relief in his plaint, provided that where no such damages have been claimed in the plaint, the court shall at any stage of the proceeding allow the plaintiff to amend the plaint on such terms as may be just for including such claim. So also, the dismissal of a suit to prevent the breach of an obligation existing in favor of the plaintiff shall bar his right to sue for damages for such breach, and when particularly injunction would be refused, so an injunction cannot be granted as it was mentioned under Section 41 of the Specific Relief Act, and such grounds are to restrain any person from prosecuting a judicial proceeding pending at the institution of the suit in which the injunction is sought, unless such restraint is necessary to prevent a municipality of proceedings, and secondly, to restrain any person from instituting or prosecuting any proceeding in a court not subordinate to that from which the injunction is sought, and thirdly, to restrain any person from applying to any legislative body, and also to restrain any person from instituting or prosecuting any proceedings in a criminal matter, so also to prevent the breach of a contract, the performance of which would not be specifically enforced, and also to prevent, on the ground of nuisance, an act of which it is not reasonably clear that it will be a nuisance, so also to prevent a continuing breach in which the plaintiff has accepted silently, and so also when equally efficacious relief can certainly be obtained by any other usual mode of proceeding except in case of breach of trust, and also when the conduct of the plaintiff or his agents has been such as to disentitle him to the assistance of the court, and lastly, when the plaintiff has no personal interest in the matter, and under such above mentioned grounds, the very injunction can be refused. So, notwithstanding anything contained under Section 41, where a contract comprises of an affirmative agreement to do a certain act with a negative agreement express or implied not to do a certain act, the circumstances that the court is unable to compel specific performance of the affirmative agreement shall not preclude it from granting an injunction to perform the negative agreement, provided that the plaintiff has not failed to perform the contract so far as it is binding on him, as it is provided under Section 42 of the Specific Relief Act. So, the very main features of injunction, as we found, it is a discretionary remedy. However, the discretion is required to be exercised judicially. It is required to be exercised in accordance with legal principles, as it was decided in Best Degree College versus Lakshmi Narayan in 1976 by the Supreme Court. It is more in nature of equitable relief than a legal remedy. It was also decided in the same leading case. It cannot be claimed by the plaintiff as a matter of right as it was decided in the same leading case, being admissible relief, it may be referred if the conduct of the plaintiff or his agent disentitled him for the assistance of the court, or equally efficacious relief can be obtained by any other usual mode of proceeding except in case of breach of trust as it is provided under Section 41 of the Specific Relief Act. So, injunction will not be granted in case of breach of contract if damages are found by the court as adequate remedy, as it was decided in the leading case, D.V. Rawal versus Patan Municipality, 1967 by the Gujarat High Court. So, in case of violation of a rule of law, the court will not hesitate to issue injunction on the ground of chaos. So, in a case, Barbary versus Enfield, London Borough Council in 1967, the Allahabad High Court held that court will not hesitate to issue injunction should and to fulfill the requirements of law, the court will see it does fulfill them. It will not listen readily to the suggestion of chaos. Following it, the Supreme Court in B. Prabhakar Rao versus State of Andhra Pradesh in 1986 has observed we are governed by the Constitution and constitutional rights have to be upheld. Surely the Constitution must take precedence over convenience, and a judge may not turn into a bureaucrat. So, in our upcoming video, we'll discuss the very declaratory remedy as provided under the very provision of declaratory action or declaration as an equitable remedy or as an ordinary remedy.